I'm back. One of the dogs saw an ant and decided to bark his head off. Okay. Um, so yeah, you want to be accumulating all the only you are going to know if something's missing. The judge isn't really going to know, right? So you need to make sure those things get ordered and in. Then, and this is going to be in one of the letters the judge sends you, but people tend to not read, right? There is called a 5-day evidence rule. You have to get all the evidence into the judge that's going to be used for the hearing 5 business days before the hearing. And any evidence you don't have at that time, you need to let him know by letter. And I would fax it into that fax number with that barcode page that you get. If you don't have it, you need to call them and ask for it. So if you don't, the judge can refuse to consider any future evidence, even if it comes in a little late. He could, but by giving him the 5-day notice, and I say 5 business days, you have to take that seriously. That is not 5 days. We have a weekend in there. So that means it's definitely at least 7 days. And sometimes there's a holiday in there. So I just do a flat rule of thumb, 10 days. Now so my evidence, I'm getting in, but I get my 5-day evidence letter out about straggling evidence that isn't arrived yet. I get that out 10 days before. My brief, I try to do 30 days before. That's just me. I become extremely anal about trying to get it out way earlier than waiting to the last minute to finish it up. It used to give me agita. So you need to step on it to get that evidence. It takes forever. It takes hounding providers sometimes. It's very unpleasant, but you have to do it because you need this evidence. It is your case and only your case. So getting all that medical evidence, I would start doing the second I get the recon denial. And I would add, if you're going to try to get a representative, while I think you should have done it before you applied, that's just me. You need to do it now. If you think you're going to get someone for the hearing, do it before you even appeal for the ALJ hearing. Let the representative do it. If the representative says, well, you go ahead and appeal and call us later, I wouldn't even bother. Any representative, I think, who's going to seriously work in her case is going to want to get it at that time. They're going to decide when they talk to you whether they'll even take it at all. But if they're going to, that is a time to get them on board. That way, they're going to know your case that much better. They're going to do the appeal for the ALJ hearing, and they're going to have all that extra time to work on your case. If you don't get them till later, you just lost months of attorney work on your case. And something tells me you're not going to be doing attorney work on your case, right? So you get the denial and recon. You don't have to file the appeal right away. Contact the SSA and say, I need a copy of my file right away. I have to, appeal and I need to know what's in it. Okay. That would be your field office. And then if you're going to get a representative, that's what you want. Now's the time. You already have that request for the thing. And by the way, I'd follow up with them every week and stay on them because they could make you wait months. And now your hearing's over and you have nothing. So you have to be really diligent. I'd get the representative at that time if that's your plan. If you don't plan on a representative, then that doesn't matter. The rest of this does. You want to getting all that evidence and getting it in. Super, super important. Knowing your file inside and out, super, super important. You have to know what's missing so you can get it. One way to prepare for the hearing is to look at your function report that you submitted on initial. You might have submitted another one on recon because they've been doing that the last couple of years, which isn't really a bad idea. You want to see what you told them were your limitations. Look at question number 20. Did you say that sitting was no problem? Are you sure it's no problem? If you are, fine. The truth is the truth. But if you haven't even tested yourself, and again, this would be particularly for people with physical problems, maybe back problems, leg problems, potentially neck problems. Sitting is, believe it or not, using your back muscles. So I would suggest you test yourself at the table, sitting upright, and can you sit there for 2 hours at a time with only a 15-minute break in between? After your second 2 hours, you could have a 30-minute break for lunch. And then do it again for 2 hours and see. pain-free? Oh, well, then you probably have no sitting problems. On the other hand, if you're sitting there, a half hour and your back starts humming, or your legs go numb, or your hip is flaring, you got something going on with sitting. And it's probably connected to one of the body parts you told them about. So that means you probably answered your function report wrong. And you might want to be prepared at hearing to explain when the judge asks you about your day-to-day, take your notes of what you want to say. That, on my function report, when they said sitting, I just thought it meant if I couldn't sit, but I can sit, judge. It just starts to hurt, my lower back, or, so you have an opportunity to explain that the different answer, what it really is, and how you were confused and why you were confused. That's what I'd be doing. The questions on the function report, many of them are often asked by an ALJ. They're going to ask you if you're shopping. Why is that? Because some people say, I never get to leave the house because I'm always in pain. But then they answer, yes, I go shopping. You just had an inconsistency. So know what your inconsistencies were on your function report. If you did it yourself, you invariably have some screw-ups. And it's your opportunity to explain how you misunderstood the question. But even if you don't do that, those are a lot of the questions the judge will ask you. So if he asks you about shopping and the only thing you do is order it online and pick it up curbside, you want to clarify that that's how you shop, that you're not exactly mauling it, spending 2 hours in the grocery store, lolly dolly, particularly when you say you can't walk or stand very long. Same thing would be true for mental conditions that you allege disable you. If you say, I have anxiety attacks and I can't hardly ever leave my home, but then you do go to the grocery store for an hour every week to get groceries, that might look a little inconsistent. It might look like you're exaggerating before. Again, because there's other alternatives to going in the store and spending an hour. It could be, I only go to the convenience store now and I grab something quick. Or it could be my brother-in-law actually gets me groceries every week. Whatever the case may be, now's your opportunity to explain it. If your shopping is limited in any way, like you don't go to the big store that you get delivered, the only thing you do is you pop out to a convenience store for milk if you run out or whatever. So when you said, yes, I go shopping, that's what you meant. That's when you clarified. You want to make sure the judge has a clear picture, as opposed to one that shows that you're better off than you are, which is what the lower levels thought, right? So you want to give him reason to, and speaking of that, when you get that big file from the OHO with all your exhibits, in the A section, there's something called a disability determination explanation. And in there, you might have to read it more than once. It's kind of lengthy. They talk, the person who made the final decision below explains what all they had, what their medical expert said you could do in terms of residual functional capacity. That doctor will have signed off on something that's a page in there. You can get a lot of information as to what findings they had, and you already know they result in a denial under the law. So you want to go back and maybe find out which findings are not true. And go into your evidence, your F section now, and find which doctor's reports dispute such a thing. It could be between the lines, or it could be overtly disputing. Sometimes it's reading between the lines. But, like if I'm trying to think of an example, like if you say something like, they say in there, he doesn't complain about his lower back for 2 years or whatever. And you find these records in there, well, yes, I certainly did. This is why I went to Dr. Jones on March 5th, 2023. You want to be able to pull that out, maybe take a little note, and refute that, the SSA's holding below judge was not good because, and normally we would do this in a brief, but, to say, because, the DDS found that, the lower level found when they denied me that there was no complaints, but yeah, look at exhibit 4F at page 25. Here's the quote, so you can start cherry picking, because they cherry pick. So you can cherry pick on your own behalf. all the evidence that points to what you're trying to show them. Or if they denied it existed, and there you have it. So it's your time to get into the weeds on your own medical records and point out why this supports that you can't do this, or you can't do this more than this long. You know, you have to really push for it. All right. But the biggest thing, of course, is making sure that every medical record gets in there. Everything. If there is something, if there was something from before your alleged onset date, and it's a medical procedure or treatment that you had while you were still working, but things were growing bad, I would make sure to order those records. If they're 30 years ago, perhaps not. But if it's, a few years before you got to the point where you couldn't work, if it's one of those things where it's somewhat progressive, I would bring those up. I would get those records. If they're more than X years old, you might not be able to get them, but this is something I would have done on initial though. But now's the time, because the judge is the one that pays the most attention to all your details, I think, than anybody else that has ever looked at your case before. The ALJ has a far more grasp on your case by the time it's said and done, when his decision comes out. So I think I'm losing my voice. Those are just a bunch of things I would make sure to do. If you're denied on recon and you have to appeal, gosh forbid you've already appealed, this is what you should be doing. Make this your homework assignment every day. Get it organized, get ready. And I do have videos on what to expect at your hearing, and things to consider at your hearing, the whole path of the hearing, and also things not to say at your hearing. I think that's its own playlist. Anyway, I hope this helps, because I know it's really nerve-wracking when you're heading into hearing. It's very nerve-wracking for people with attorneys or non-attorney reps, and it's, I think, extremely nerve-wracking for those who don't as well. It's just got to be worse. So I feel for you. Anyway, all right, hop to it. You got things to do. Bye, guys.